Welcome back to the TuckerAllen podcast. I'm Scott Trout, and we continue to bring you everything and the information regarding estate planning and elder law, defining terms that are confusing for you, and really trying to explain some of the basic principles. And we're going to do that again today as we're joined by Missy Shands Manning of TuckerAllen. Welcome, Missy.
Hi, Scott.
Glad to have you back. And we're going to talk a little bit about how unmarried couples are treated. But before I do that, I want to make sure as I start every podcast and make sure everyone knows that this shouldn't be taken as legal advice. And obviously it's not an attorney-client relationship. We want to just educate, provide some talking points. We encourage you, as you're listening and watching, go get an attorney who practices exclusively in this area. They'll be able to answer your questions in more detail. Your facts, your circumstances, your estate often will, bring about something different than we're talking about today. So just use this as write down some questions, get some of these terms defined, and learn, right? And education is power, and that's what we're here to do. So, obviously, if you want to consult with Missy or some of the other attorneys in the St. Louis metropolitan area or in Kansas City, you can call us at 866-335-3375 or find us on the web at TuckerAllen.com. All right, Missy, let's talk about it. It's something that, a lot of people, they think, oh, I have to be married, but they don't think about, what happens when you either have a relationship, you acquire property together. How are unmarried couples treated for estate planning?
So the really sad part is that the law doesn't treat them any differently than strangers. So if they're not married, there are no rights and no special privileges for your life partner or boyfriend or girlfriend or whatever you want to call your relationship. It's awful. So
that's a tough one because, you've acquired all this property together. Maybe you built a house together. You've never, your state may not recognize common law marriage or whatever it may be. It may be titled in individual names. I assume that the house wouldn't pass automatically, right?
Correct. So unlike with a husband and wife, if they own a house together, the house would automatically pass to the surviving spouse. But with you guys not being married, then it doesn't pass to the spouse. It actually, if the spouse owns the house and you're the one that doesn't own the house would go to your significant other's children or parents or siblings or something like that, and you actually would no longer be able to stay in the house. So that's a huge problem for a lot of unmarried couples who have a house in just one of the partner's names.
So even worse, let's say they get sick and they go to the hospital. I've seen this, of course, I play a lawyer on TV kind of thing. I see it on TV. They're not entitled to make healthcare decisions or get the information, right? If they're not related or married, right?
Correct. So sometimes the hospital is going to be more understanding, but legally, if you are not married or you're not some sort of family relative, then you have no right to actually get any information about your significant other's health and make decisions for them.
So I was going to say that can all be fixed, right? But that's the point. What, maybe you can talk quickly about what that document is. We don't have to get in the details, but what is it that people can do to execute to help fix that problem?
So you could get a healthcare power of attorney that nominates your significant other to make healthcare decisions for you. And you can get a HIPAA waiver, which authorizes your significant other to get access to healthcare information. We have several clients that have come in where they don't have a good relationship with their partner's children or their partner's family, and they're cut out and they can't get in to see their significant other in the hospital. So it can be a really unfortunate situation, and it's easy to fix with just a healthcare power of attorney or a HIPAA waiver.
Yeah. That goes for widowers too, or, divorced, and, they can nominate people to make healthcare decisions and financial decisions for them. It's not just about having we think unmarried couple, we think maybe young, middle-aged, they've just been living together, they've been dating, but this goes for older people as well that need to identify individuals to make those decisions for them and have access to the medical records, right?
Yep.
Yeah. So now let's just take the scenario where couple living together, one passes away, not married, no will. What happens to that house? Here the surviving person is living in it, but what happens to the house?
So if the surviving couple isn't on the deed for the house, then they can be kicked out. They have no right to live there anymore. They'd be considered a squatter. hopefully the family would recognize that this is important and would be able to make arrangements for that person to find new accommodations, but they literally could go and change the locks. If they co-own the house together, one couple and then the other couple, the half that belonged to the couple that passed away, that would go to their family, and then they're going to end up co-owning the house with possibly that person's children. And that makes for a really stressful situation where the kids might want their money and they want their half of the house. And then obviously the surviving couple wants to stay in the house. So that leads to great tensions there as well.
We had a lot of conversations on what would happen if we weren't here, and I don't know. TuckerAllen was super convenient. It was so easy to go through and get the package that we needed.
The website was simple, easy to use. You could schedule a time to actually meet with somebody.
It's one set fee for a will, one set fee for a trust.
It's our wishes in place. It's everything we want for our daughter.
Yeah, I mean, it's complicated. And we talked to Ryan Foley, and we talked about, the will, just the idea of what a simple will is. And I mean, that's the whole point here. There are all these, if you imagine, there's these pitfalls along this road that you're traveling. And, if you don't take the correct road, the dangers like this, if you're unmarried and you haven't planned and you haven't done a will, for example, to, as we talked with Ryan, tell everyone when you pass what happens with this property. Then you wind up in a situation like this. And I've had it where we've seen a couple who were unmarried and didn't take any steps beyond just living together. And then the children really never approved of the relationship to begin with and kicked the surviving person out. It was very rough. And so I think that's the message. And I guess other alternatives, let's just put aside the will for a minute, which I think is the right solution. It's cost effective. It's really easy. But are there other alternatives to ensure that a property passes to your significant other?
So one of the easy ways to do it is to do a deed for the house. You can add the person on as a co-owner. So you guys would be joint tenants with right of survivorship. So if one died, the other one ends up owning the house entirely. They can also do a beneficiary deed if you're not quite ready to put your significant other as co-owner on your house with you. You can say upon your death, that person will then own the house entirely. And then again, getting a will in place. A third option is probably the best option, is to set up a trust. So that way there's no chance for anyone to step in and say, this property was owned by my dad and we don't have the will, we don't know where it is, we don't have this deed, kick this person out, we're changing the locks. There's no chance about that. The house would be owned by the trust, and then the trust says very clearly that this person gets to stay in the house.
So, you think in that scenario, you've got the deed, but there's no will. So what happens if there's or let's just say this, if someone dies without a will, do they have to have a probate? We talk about court interaction, and that's kind of what we don't want. But when would that occur?
So if you have just a will or no will, you're going to end up having to go through probate for the house. If you end up getting a trust or a beneficiary deed to go with one of those, then you can probably avoid probate as long as the person that you've put down is still alive.
So we've also talked earlier about the healthcare and making the decisions if you're sick and who helps. I mean, there's always that fight if there's nothing in place and you have children. I imagine there'd still be a fight if you designate your significant other. But let's talk about the financial. Let's say you're in the hospital, you can't make pay your bills, or you can't make financial. Is there a similar document for financial decision making that you can appoint your significant other?
Yeah, so it's a durable power of attorney. It appoints someone to make financial decisions on your behalf when you're incapacitated. So usually if you guys are living together as a couple, one of you guys is paying the electricity and one of you guys is paying the gas bill. And if you're out of it in the hospital and you can't do those things anymore, someone needs to be paying those bills, and your significant other couldn't gain access to that account because they're not your spouse. So having something like that in place makes things much, much easier on your significant other and your family.
Right. And then you talk about the beneficiary deed or the warranty deeds and all the things that you I know I've had these conversations with people that well, I've done all this. I did transfers on death. I did this. And so I don't need a will. But what about all that property you forget about, right? Does that fall into the whole
Yes.
probate part?
Yeah, there's actually a lot of people who believe that they don't need a will or they don't need a complicated will or anything like that. Actually, what actually happens, we see it all the time. They end up inheriting money from someone else, somewhere else, or they acquire something and they don't think about it like, oh my gosh, now I've got this property or this car, I need to update and get a will. Because obviously every time you buy a new car, you don't run off and update it. So plan in place and having a will in place for all of those contingencies is a good, safe thing to do.
And I imagine you think about this unmarried couple, you'd want each of them to have a will, right? So that they each can kind of give however they want it to do, not just one, but two, right?
Yep. So for example, if their second marriage sort of situation, they've been divorced, they each have kids from a previous marriage, you could name your spouse to get almost all of your stuff, sorry, not your spouse, your significant other to get almost all of your stuff and give some stuff to your kids. So you get to have the choice of what's going to go where without having it automatically all go to your children and nothing go to your significant other.
And I've got plenty of time. I'm young, I'm healthy, but I think that's the whole thing that this pandemic, I believe, has taught us, is that you never know. And so that's why I think it's important we talk about things like this and encourage people to take action, at least have a consultation and understand what a small investment, and I mean it's small comparatively, for a will, and that it can do for them, right? I mean, it's a small investment comparatively, right?
Yep.
Yeah. And I think it's a step one. I mean, there are plenty of things where we haven't talked about a trust and what you should be doing to properly plan. But what is complicated, and I talked a little bit about this with Ryan, is that there are all kinds of things, particularly in your state, or tax implications, or how things are titled currently, to make sure that they're properly put into a trust, or the will, and identified. It just gets so complicated, and that's why we encourage people to let's break it down like you did today. How really you never really think about it. I think wills, I'm going to take care of my wife and my kids, or my husband and my kids and their kids. So great thing about unmarried couples, really, to kind of just take that and identify a really important topic for people. So I appreciate your time, Missy.
Well, thanks. It was a pleasure speaking with you.
Yeah. So as we continue to bring you information like this, we encourage you to seek a consult with someone who just practices exclusively in estate and elder law, like we do at TuckerAllen. Obviously, Missy and the team here in the St. Louis metropolitan area are available for a consultation. You can find them on the web at TuckerAllen.com, or you can give them a call at 866-335-3375. So stay tuned for more information. We continue to bring you this in our weekly podcasting. We'll be scheduling a town hall soon, so check out the web for that at TuckerAllen.com. And until next time, have a great week.